says that she loves me. Isn't it lovely when the one you lusting is the one you're loving?
What is it? The Supreme Court is going to be hearing this guy, and I looked up Mr. Bloom.
Yes.
And his long standing.
Yes.
He tried with the child in Texas many years ago.
Abigail Fisher, correct.
And it didn't work.
Did not work.
And now they got a Supreme Court that will probably overturn it.
Yes.
I'm of two minds. I feel like, going to Drew University first week on campus, I was confronted with some horrible ass buff type of dude, Biff, somebody named Biff. Oh, you're just here because you're part of a program. This notion that somehow if you're black on campus, you must be, less than. But he got his whole life. I think his eyebrows are not growing back in yet because I was a lot worse than I am now. But I just think about it. It made me feel some ways, and I was like, maybe I am here as a quota, but I know I'm smarter than you. I know I'm better than you. Like I just felt like as a person, I'm better than you because I would never. Who says that to somebody? So I'm about to hand you your ass, and you're gonna get your life and go sit down in a corner and never come back this way. But a lot of people, are made to feel less than when they get in, as if college is really about your intellect, because it's not. It's about the whole social. Talk about it.
So, again, thank you again for having us, Karen. I think the first place to start in the conversation is to acknowledge that the college admissions process now is not fair. It already skews heavily towards students of means, right? These are the students that can afford test prep classes. These are students, especially when you start to talk about Ivy League schools or highly competitive schools, you're often talking about parents that can afford for counselors that can coach their children through the entire admissions process. You also talk about a practice that is not being challenged by the Supreme Court or this case, which is legacy admissions or preferences for athletes. And so when we talk about the things that people are not challenging, I think it says a lot more about who we are as a country and as a people. We're not challenging things I think are patently unfair and that actually generate inequality. But instead, what we're going to focus on is a very narrowly tailored practice, which since about 2003, you had Greta v. Bollinger, which said racial quotas have been illegal since the 70s. So anybody who says that they don't know what they're talking about. So we're going to take that off the table. Since 2003, what we've said is, look, race can be one of many considerations, and race can be a plus factor, but not determinative in how admissions counselors make decisions about who's in or out of a class. Whether or not that is constitutional is the question before the court this time. And we have 6 votes that will strike it down. The open question is, how far will the court go? And that is like the $1 million question, because if the court rules narrowly and just says explicit considerations of race in the admissions process, let's do away with them. What college admissions counselors are going to do, they're going to take the box off the application and they're going to keep doing what they're doing. I think the court will go farther than that, and here's why. You have one with the Harvard case, Ketanji, Judge Jackson has to recuse herself because she's on, I think, the Harvard Board of Overseers. So you only have 2 Democratic appointed justices that are going to be on the Harvard case. So we're already 6-2. And we're very likely that's going to be your margin in that case. I think it's 6-3 on UNC Chapel Hill. But what I think it will ultimately mean is every selective institution. And so let me be clear. I think when we say selective, we're not just talking Harvard and Yale. The University of Georgia is highly selective. The University of North Carolina, Chapel Hill is highly selective. These are states with large populations of Black people. And in the case of in Chapel Hill, they've always had large, relatively speaking, Black student populations. We've seen what happens in California when you go colorblind. And I put colorblind in air quotes because I don't think people can see me in the car. But what colorblind really means in college admissions is you're going to have a lot less Black students and Hispanic students. And if you've been to UC Berkeley, you'll see what it looks like. If you've been to University of Michigan, the Black folks in particular that you see in many cases are athletes. Because again, the preference that they're not going to touch is the preference for athletics, legacies. So we're talking about a fundamentally unfair process. And the one thing that we're challenging is the one thing that we use explicitly to find ways to diversify our student bodies. And I think that where this decision will fall, it will go further than just admissions. We're talking scholarships, we're talking outreach programs, we're talking about initiatives to diversify faculty and staff. All of these decisions will have to come under review, because the legal question is can an institution that receives federal funding, which is every college and university, just about, because they all get federal for student loans, and that's how students pay to be there. So almost every college takes some form of federal support. And if you are a governmental institution, like a state college or university, you're subject to the 14th Amendment. So there's a question of, are you violating the Constitution if you're considering race in any of these decisions that you make? So this is big, because if the court goes really far, Karen, if the court goes farther and says diversity is not a compelling state interest under the 14th Amendment, then that means all government programs that consider race are on the potential chopping block. So that's minority contracts. So I don't want people to be lulled to sleep if the result doesn't seem to explode immediately, because like so many Supreme Court cases, it's reading the tea leaves and seeing what the next set of challenges is going to be.
Right, because they've been playing a long game.
Yeah.
Yes.
So we have not. We react.
Yes.
We react. We react. We react. So, and the reason why I am not leaning into the hysteria around it is because there's nothing we can do about it at this point, right? I mean, they're going to decide this week or next. We can be up in those justices that were put on the court to do this, because they were put on the court to overturn Roe v. Wade and to overturn affirmative action. This is why they were put on the court. They know what their assignment is.
Yes.
There's no amount of ruckus that we're going to raise that's going to change that. They gave you the middle finger on Roe v. Wade, and that's white women. That was white women, really, that they were saying, you're going to have these babies because our population is dwindling. If they didn't capitulate to that, they're not going to capitulate to this. So my thing is to lean into where the opportunities are once they do this. Let's make them pay for it.
So yes and no. The reality is, can you stop this decision from happening? No, it's going to happen. I think the bigger question is, well, what do we do about it? Right. And so the do about it once it comes down. I think one of the questions is for the institutions, because most college and universities are going to say, we do care about diversity. Even the ones that don't have great numbers, they try. Many of them try. And I think for those colleges and universities, it's how do we find race neutral alternatives that get us to the same outcome? Because one of the questions that we're going to have to look and see when the opinion comes out is what happens with race proxies. Because when you listen to the oral arguments, one of the things that the more conservative justices are on the lookout for is colleges that they view as potentially gaming the system, where they'll essentially get to the same outcomes. They'll say, oh, we'll get rid of the box, but we're only going to recruit from these neighborhoods where we know Black people live, right? Race proxies may also be in jeopardy, right? And so again, that makes that job harder for an admissions office. So I think one is for colleges and universities that care about diversity, what are the most robust set of alternative measures that you can put in place to ensure that you at least don't lose ground in terms of the diversity on campus now? Because with the folks in California and Michigan who've banned it at the state level, we've not seen that diversity return. What we've seen is Black and brown students go out of state and go other places. What we've seen is the most selective schools within the system, let's say University of Michigan, Ann Arbor, UCLA, UC Berkeley, there just aren't any Black students, again, other than the athletes. And unfortunately, then I think we see other students go to what they call, other parts of the system. The bigger question that I have, and one that I think, to your point about what we do about it, I'm a Morehouse man. I'm from an HBCU town. I think this is the opportunity for our historically Black colleges and universities to say, look, there's nothing in our admissions program that's going to change. because our applicant base is already diverse. So, I mean, checking black on an application to Howard is like, okay,
so
why are you
right,
here?
and
That's why you're here, right? And so
right.
the question is, do our institutions have the capacity to service what could be a spike in enrollment, because they're already seeing higher enrollment post George Floyd. And
and they're stepping up their game, all of these schools. I mean, you got Cheryl and Eiffel going to Howard.
I think that's a beautiful thing. I think it's a beautiful thing. I think it's a beautiful thing. And I do think this is an opportunity. But it's also an opportunity, I say, Karen, also, we should be challenging legacy admissions. Because if you talk about who's actually consuming the seats in a fixed number of classes, you're talking about legacy admissions and folks who are being admitted under a different set of standards that is not being challenged, but I think that's patently unfair.
So what I'm hearing you say, which I think, again, strategy being a thing, we need to have strategic think tanks all over the place about a different, we used to, when it Spotswood Robinson and Paulie Murray and Thurgood Marshall, and like there was a cadre of legal minds strategizing around how we move legally. I don't see that anymore. Everybody wants to be on TV chasing, let me not say that, but you know what I'm saying without saying it.
I think people are, to some extent. I think
who are those people? Because those folk were legendary in strategizing what the next moves would be for Black people. Now, Brown versus the Board of Ed feels like Juneteenth to me in many ways. I'll just say that out loud, out my mouth. Yes, I said it. I feel like it was not thought about how white folk would move to get away from us and how they would terrorize our children in these schools that we forced us to go into through busing. I thought that was destruction of a lot of amazing Black souls went into that we need separate. No, we need equal. Give us textbooks with all of the pages. Make sure we lost great teachers. We lost great schools. Dunbar went down the tubes after that. It's like there's so many schools that were diminished as a result of us needing to be integrated. We don't need to be integrated. We're fine. We're fine.
Clarence Thomas would agree with you.
Good. I'm right. He'd be right on that too.
Yeah. Well, no, yes and no. And so one, as much as I love that our HBCUs are getting the attention they deserve, and to some extent getting the resources they deserve, and that more families are considering them that may not have been considering them before, I do think that preserving the full universe of choice for students of color matters. And the reality is, if you sat in a classroom at some of the, and I'm gonna put elite in quotation marks too, because I question that too. But if you sat in a classroom at Princeton, it's not like Black folks are everywhere. It doesn't look like Norfolk State. You know what I'm saying? So the idea that Black students are consuming space left and right is just not true. Unfortunately, if the court goes the way that we think they will, we'll probably see what we've seen in other places, unless these institutions make again, to our point earlier, a commitment to doing even more to recruit and retain these students, to recruit the faculty, to bring in the staff, to bring in the people that create the environment where these students can thrive and not be isolated. The court should not be stopping that, but again, it all have to be under review. Lawyers like me are gonna have to review policies and what these schools are doing and offer these things up. But I think, Karen, again, at the end of the day, it matters. And it matters that schools be given at least the flexibility or the tools to diversify the people who go to their institution.
Jared Lodehold, I'm not going to argue with you in that shot. That's the way Clarence Thomas, that's a shot. But, no, and it's okay, because I feel like.
No, but that is his point. That is
but he's coming out, he's coming at it through a white, like that man's problematic on so many levels. Let's throw Clarence Thomas, and don't ever insult me again to say, that Clarence Thomas.
But that's his view.
It's an insult. It is. Stop. Let's talk about the truth. And again, I'm not undermining Spotswood Robinson. I think a lot of for a lot of us, we think that even Martin Luther King was like, I fear I've integrated my people into a burning house. At some point, you like to think of the better angels of men. If they just would see how brilliant we are, then maybe if they just would see that we're human beings, if they just would see that somehow that's the problem. That's not the problem. So I've identified that the problem is not whether we're, as good, or if they would just see that, then we wouldn't have racism anymore. I think the inherent bias in this country will always relegate us to that. So I'm saying, go ahead and have your, lack of affirmative action, and we don't have to be there while we go over here and build. Let's go over here and build, and let's create industry. I'm no longer going to sit and beg to be somewhere where I'm not wanted. And I feel like it's like moving into neighborhoods. Yes, we should have access to everything. But if you want a red line, I'm gonna have the best damn community possible, because we can do that. I hear you. 866-801-8255 is the number, whether y'all agree or disagree. Let's have a conversation. But this decision is going to go down. So how we respond to that, I'm not going to be, oh, you didn't let me in. I agree with you. Maybe strategy should be, let's go after the legacies. Let's go after these legacies. Maybe there should be a lawsuit brought by a Black person. But who are the legal entities that would do that? That's what I need.
The NAACP Legal Defense Fund they're the most out front group that you see on these cases. They're the ones that immediately come to mind. Now, I do think an important point that you do raise is what we do not have is this web of highly motivated, well-funded, highly strategic legal organizations like Students for Fair Admission, like the Pacific Legal Organization, I forget the last part of the name, that are funded by folks like Leonard Leo and like Harlan Crow. The name who you may recall is a guy who bought Clarence Thomas's mom's house, took him on nice trips. These are the same people that are funding these organizations that bring what they call impact litigation. Mm-hmm. Unfortunately, and that's actually what the LDF used to do. And they still do that, but to some extent they're outmanned because all of these well-funded organizations, some of them are run by, you talked about Edward Bloom. I'm blanking on the guy who worked for President Trump, Stephen Miller.
Bannon? Oh, Stephen Miller. Oh, Jesus. That guy.
But Pacific Legal is his organization, if I'm not mistaken. So they all have these innocuously sounding organizations that bring these cases that go after these long-standing targets of the conservative movement, of which affirmative action in higher education is one of them. They've already gotten Roe, and to your point, and one of the reasons why I am standing my ground, I guess, on this issue is because I know what the power of precedent means for future cases. Mm-hmm. And so that matters a whole lot, because then that can be
so here I know what you're saying, the domino effect of that. But if we're being honest, right, the way they are teeing this up has been planned for the last 12 years. Right?
More than 12. Since
Obama.
Like 73. No, Bakke, Bakke. So this is like mid-70s case out of California.
Okay, so they've been doing this since they were forced to actually, because it took them 20 years to actually implement desegregating in schools. But you think about a country that works. I'm gonna play a clip. Let me play this clip because I think it just captures most of the folk in this country are ignorant, Black and white, right? Anyway, they self-segregate. 3/4 of white identified people who identify as white segregate on purpose, right? So they're already moving away. They got their own schools. They got their own enclaves. They never have to be in community with Black folk. So we're like begging to get into something that, to me, I'm like, let them have it, see how it works when we're not there. Play that clip, Smiz, of the white lady talking about Juneteenth.
Juneteenth is, what's happening to the white people? They have a Black Miss America. They have a Black college. They have a Black month. What do we have? And now they have Juneteenth. Yes, I understand there was slavery, don't get me wrong. But there was also a Holocaust, and that was more recent than slavery. But you don't hear the Jews saying, gimme, 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 gimme. What's the point of Juneteenth? What is it?
Yeah, so
I don't know.
Yeah, you don't know anything. And that's the problem, people of the Jewish faith after the Holocaust didn't have to say gimme, gimme, gimme. Well, they got Israel. It was going to be Uganda. Then it became Palestine, which became Israel. And every year America sends a check, right? America pays money every single year for the harm that was done. And they should, right? Black folk are owed reparations in this country, as are Black people everywhere that there was enslavement. That said, I'm just like, the ignorance that is here, Jared and Sina, is so stunningly, deeply woven that the energy that we do have should go into building, not trying to, oh, please stop being racist and here, educate. Now, I think people like you should be out there fighting the good fight. We need the legal minds. We need the brilliance to fight. But I'm going to spend my time building over here to make sure that we're going to be good no matter what.
Or we could do both.
Yeah, I think we can. I said,
I think it's both, and I think we want to be at every table in the country that matters.
Yes,
and
I agree with that.
We need to be everywhere. And again, for a process that itself is fundamentally unfair and that is already skewed, we're making it less fair. That's already unfair, in a way that does limit choice and to some extent opportunity in ways that I do think disproportionately is going to affect Black people. Because we've seen it in California, we've seen it in Michigan, we've seen it in the states that have already banned this in their public colleges and universities. And that's not a good thing. That's not something that we should see and replicate and want to do. And I think as Black folks, we do need to build our Black colleges anyway, right? Like, they are our assets. We should invest in them regardless of what happens. We're just going to have to, because to some extent, there's a real capacity question and a challenge that I hope we rise to, where students who may have gotten into the University of South Carolina or Clemson may not get in under this new regime. And South Carolina State, they're waiting for you, that we never left, right? And I think institutions like South Carolina State, Claflin, Morehouse, Howard, you name it, we never left. We've always been there for Black people and Black families, and they'll continue to be there. But again, I think to a point, what's the federal government's response? We're funding HBCUs at a decent level. We could always fund them better. And they need more capacity now than ever. They need to build more dorms. They need more classrooms.
Sure.
Like, they need more things, because more students may say what they said after George Floyd, which is, why am I going to this school? That being said, I still would like to be, the whole point of the civil rights movement was so that we wouldn't be required to only be in one place. So we're retrenching a bit on that, and we're doing it under the guise of Students for Fair Admission. And I think we should be very mindful of what that does and what that creates. And the precedential value, if a court says, for example, and this would be the extreme case, but possibly likely here, not possibly like, but a possibility here, which is if they decide that under the 14th Amendment, diversity is no longer a compelling state interest. Because again, if that happens, every other thing that a governmental entity can do to consider someone's race for any governmental benefit is on the chopping block, potentially. And I think we've got to be honest about what the worst case scenario looks like. Because, for example, those minority contracting programs in Atlanta that helped build the airport and brought you the Olympics and that built that city, they're based on they're based on a Supreme Court case in Croson. And so Croson
so there won't be states' rights. There won't be rights of municipalities to be able to determine, like Maynard Jackson was like
constitutional. No, not if a court decides that diversity is no longer a compelling state interest, which is, again, it came up in the oral arguments. So this case could be the camel's nose under the tent, which again goes directly at the heart of things that we know have generated wealth, things like minority contracting programs. So yes, if a court decides that that's no longer a compelling interest, Karen, it'll be less than 12 months before you'll see a case before the Supreme Court seeking to overturn Croson, which is the lead.
No, I think you're right. I think you're right there, but I also think there's an opportunity to rebuild Black Wall Streets in that case, because I feel like before there was before there was all of this, we had several thriving Black communities that folk were jealous of and wanted to tip into. I feel like, now we build them with the fence in mind, because you know what was going to happen. I just feel like now we know. Cena Ghaznavi, we got a couple of minutes left. You want to say something?
Yeah, I guess whenever I hear about the Supreme Court, the illustrious, very thoughtful and monstrous Supreme Court that we have, when they're about to make a terrible decision, my head goes to, of course, what is the strategy? And we were talking a little bit about that. I guess my question for you, Jared, is like, legislatively, what are the pathways that, let's say there's a bigger both house controls kind of thing for the Democrats, what are the options or pathways to combat this?
Great question. So here's what we can't do. And I actually had a good brother who was a constitutional law professor. Shout out to Vinay Harpalani, University of New Mexico, my law school classmate, broke this down for me because I didn't know. And I was saying things that weren't true. But I said, let's codify the ability for, same way like codify row. Well, what he made clear to me was, we're way past on the admissions and affirmative. We're far worse because states have already banned it in ways like years ago, like mid-90s. I was like, totally lost sight of that. So there's no codifying the kind of race conscious admissions that we want to keep, especially if the Supreme Court says that that's unconstitutional. Congress can't go back and say, yes, it is, because Marbury versus Madison, the Supreme Court says what the Constitution says it says, right? What we do have, and I actually think we don't talk nearly about this enough, is you have a set of programs that the federal government has funded for years called the TRIO programs. If anybody ever did Upper Bound, I did Upper Bound, I did the TRIO programs, Karen probably did the TRIO. The TRIO programs are the only programs in the federal government that are investing in many cases, first generation low and moderate income students around college access and college preparedness. The amount of money that we spend on these programs is laughable, given how much of an impact that they have in this. We've got data and generations of folks who were in TRIO programs who benefited from those. We need to dramatically expand how much we invest in those. And that's Congress, that's appropriations. We can do that FY24 right now, but definitely we need to be prepared for FY25.
And she smiles and says that she loves me. Isn't it lovely when the one you love thinks